How contract law works. Offer. Generally accepted definition of an offer would be a statement of terms on which the person making the offer, the offeror, is prepared to be legally bound. For example, if you give me £1,000, I will give you my car. An offer must be certain and definite. A mere statement of the price that the offeror may be prepared to sell something at will not be classed as an offer. In Gibson v. Manchester City Council from 1979, a letter from a council which stated we may be prepared to sell you a house for £2,180 was not regarded as an offer by the House of Lords. The courts draw a distinction between an offer, which is a firm proposal to be legally bound, and an invitation to treat. Rather than a clear statement of terms on which an offeror is prepared to be legally bound, an invitation to treat is simply an invitation to enter into a negotiation with a view to buying something from the inviting party. What is actually meant by invitation to treat? When we say treat in this context, we do not mean a nice sugary dessert or a gift of any kind. It comes from the word treaty, which is an agreement between two or more countries, which is in many ways similar to a contract. Treaty coming from the Latin treatis. An invitation to treat, therefore, is an invitation to begin negotiations that may lead to a legally binding agreement. In Pharmaceutical Society of Great Britain v. Boots Cash Chemists Limited, 1953, the Court of Appeal held that items on a shelf in a shop with a price tag attached were an invitation to treat and not an offer. The question for the court was whether Boots had been selling products classed as poisons in the absence of supervision by a registered pharmacist, contrary to Section 18, subsection 1, paragraph A, subparagraph 3 of the Pharmacy and Poisons Act 1933, by putting the products on the shop shelves and letting customers take them to the till. Up until the moment the customer reached the till, they would not have been supervised by a registered pharmacist. It was held that the display of items was an invitation to treat. This makes perfect logical sense. If they were an offer, there would be a strong argument to suggest that as soon as the customer puts the item in a basket, then they have accepted the offer. Lord Justice Romer summarised this point. If a person picked up an article, once having picked it up, he would never be able to put it back and say that he had changed his mind. The shopkeeper would say, "No, the property has passed, and you will have to pay." If that were the position in this shop and similar shops, and that position was known to the general public, I should imagine the popularity of those shops would wane a great deal. This principle extends to items for sale in a shop window. In the case of Fisher and Bell of 1961, the defendant was charged with offering for sale an offensive weapon under Section 1, subsection 1 of the Restriction of Offensive Weapons Act 1959, after a police officer noticed a flick knife for sale in his shop window, with a price tag of 4 shillings attached. This was held to be an invitation to treat, and not an offer. The defendant was not guilty of the offence. Like a display of items in a shop window, the vast majority of advertisements are classed as invitations to treat. However, in the case of Carlyle and Carbolic Smokeball Limited, an advertisement was held to be an offer. Carbolic Smokeball Company manufactured a device called a smokeball, which could apparently prevent the user from catching influenza or flu if used in accordance with their instructions, which were, for the sake of completeness, inserting rubber tubes into your nose and inhaling chemical vapours from within the smokeball itself 3 times daily over a period of 2 weeks. Carbolic Smokeball put out an advertisement that stated that if a customer purchased a smokeball and used it in accordance with these instructions and developed influenza or any related illness, a £100 reward would be paid. To show our sincerity in the matter, £1,000 is deposited with Alliance Bank. Mrs. Carlyle saw the advert and bought and used the smokeball as directed. Mrs. Carlyle caught influenza. When Mrs. Carlyle made inquiries of Carbolic Smokeball Company, they told her that the advertisement was not meant to be taken seriously, and that it was an advertising puff in the parlance of the times, and that, resultantly, she would not be able to claim the £100 as stated. Mrs. Carlyle sued Carbolic Smokeball Company for the £100, and the court found them liable, holding, amongst other things, that the statement in the advertisement regarding £1,000, which had been put aside for such purposes, showed clear intent to be bound. The advert was clearly not just an invitation to treat. An offer can be terminated in 3 broad ways: revocation by the offeror, lapse of time, or rejection by the offeree. The main rule with revocation is that it must be communicated to the offeree. This can be done through a third party, as was shown in the case of Dickinson and Dodds. If it has been stipulated within the agreement that the offer is to remain open for a certain period of time, then the offer will terminate accordingly. However, the offeror can revoke the offer before this time should they so desire. If no time frame is stipulated, the offer will lapse after a reasonable length of time has passed. This will depend on the subject matter of the contract, as was seen in the case of Ramsgate Victoria Hotel Company and Montefiore. The offer to buy shares lapsed after 6 months, owing to the volatility of the subject matter. In the circumstances where the offeree or the offeror has died, when the contract is one of personal service, this will result in the contract's offer being terminated. The offeree can also reject the offer either expressly or impliedly. And now it's time for Rory Mayo's top tips.
Rory Mayo's top tips.
One thing that students get confused about is the difference between unilateral and bilateral contracts. Bilateral contracts are where each party has made a promise, for example the sale of a car. Party A promises to give £1,000 to Party B, and Party B promises to give the car to Party A. In a unilateral contract, only one party is required to make a promise. A classic example of this is a poster offering a reward for the return of a lost dog. Party A promises to give £100 to any party who finds and returns the dog. There are no other promises made. For a case law example of this, see Carlisle v Carbolic Smokeball Company, 1893. The key to remembering the difference between the two forms of contracts is the prefix. The prefix bi is derived from the Latin to or twice, and this can be seen in the example of a bicycle that has 2 wheels. Therefore, a bilateral contract requires both parties to make promises to one another. The prefix uni is derived from the Latin for one or once, and this can be seen in the example of a unicycle that only has 1 wheel. A unilateral contract only requires one promise.